officially disclosed, contains both the questions and the answers from the interview. Yet the Justice Department is still withholding the audio recordings that contain the voice of the President of the United States, who's been an elected federal office holder for more than 50 years, speaking the same substantive information contained in the transcript. The law enforcement privilege component of executive privilege not only has never been recognized in a FOIA case, but also only applies to withholding information in an ongoing law enforcement proceeding. Where does the Justice Department identify the information it seeks to withhold? The recordings don't relate to an ongoing investigation, all of which are fatal to the DOJ's executive privilege claim, as well as the Exemption 7A claim, which is the law enforcement proceedings protection exemption. Finally, President Biden has little, if any, privacy interest in his voice, especially after his long public career, and the fact that his answers are already public. Yet his substantial public interest exists in the audio recordings because the disclosure of them would enable the public to test the veracity of Special Counsel Hur's decision not to recommend criminal charges. Now, we want the audio recordings released in 14 days. Well, the court should order their release in 14 days after the case is fully briefed. In his final report to Attorney General Merrick Garland, Special Counsel Hur declined to recommend prosecution of Biden for his retention of certain classified records because he concluded in part, we have also considered that at trial, Mr. Biden would likely present to a jury that, as he did during our interview of him, as a sympathetic, well-meaning elderly man with a poor memory. Based on our direct interactions with and observations of him, he is someone for whom many jurors will want to identify reasonable doubt. It would be difficult to convince a jury that they should convict him, by then a former president well into his 80s, of a serious felony that requires a mental state of willfulness. In response, Biden's White House counsel and his personal lawyer wrote several letters disputing the accuracy of the report. Even Garland says he disagrees with it. He won't prosecute Biden, but he's disagreeing with the reason for not prosecuting. That's how things work in the Justice Department, by the way. It's Alice in Wonderland. Congress subsequently held a hearing about the special counsel's investigation and his conclusions. When asked about his conclusion that Biden came across as a sympathetic, well-meaning elderly man with a poor memory, the special counsel testified, Chair, what I can tell you is that my assessment that went into my conclusions that I described in my report were based not solely on the transcripts. It was based on all the evidence, including the audio records. He reiterated, what I tell you is that the audio recordings were part of the evidence, of course, that I considered in coming to my conclusion. Hur provides the best argument there is to get the audios. So as I said, Exemption 5 doesn't apply. This law enforcement privilege, this executive privilege, it doesn't apply. For the government to assert that the law enforcement privilege to apply, that they have to prove that there must be they must show there must be a formal claim of privilege by the head of the department having control over the requested information. Assertion of the privilege must be based on an actual personal consideration by that official. The information for which the privilege is claimed must be specified with an explanation why it properly falls within the scope of the privilege. Focusing on the privilege's third element, DOJ does not identify what information it seeks to withhold. The tape is the recording, but what information
They're telling
on that
who? Yep, they don't want
do
it
they
to
want
hear.
to withhold?
They don't want it to hear.
It merely asserts that the audio recordings are exempt from production under the law enforcement privilege. As Attorney General Garland explained in his letter requesting that the president assert executive privilege over the audio recording, the law enforcement component of executive privilege can be asserted to avoid potential damage to proper law enforcement that would be caused by disclosure, including the chilling effect on sources of information. And obviously, an audio recording is a record, not information. So DOJ's failure to identify what information it seeks to withhold is fatal to its assertion. Second, even if the DOJ identified information, the law enforcement privilege only applies to ongoing criminal investigations. This is important. As DOJ admits, the criminal investigation into the possible unauthorized removal and retention of classified documents by President Biden is now closed. Therefore, the law enforcement privilege no longer applies to information, assuming there is any, that the DOJ seeks to withhold. So if this case was like proceeding, and we say we wanted this information, they would say, well, no, we're still running the case. You can't get evidence while we're running the case. But the case is closed. And they say there are these other proceedings potentially. They don't name what they are. There's like a future potential hypothetical proceeding that might be impacted. And that's not what the law allows them to do in terms of withholding information, to cover potential hypothetical secret proceedings that no one knows about. They're just making up stuff to hide the records. The DOJ does not assert nor could it that the release of the audio recordings would disclose unpublished details of allegations against individuals, reveal confidential sources, expose investigative techniques or methods, or interfere with the special counsel's decision-making process. It already disclosed the transcript containing the substantive information. So that relates to, well, even if the case is closed, there may be material in the course of the investigation we have to keep secret, like a source or the fact that we can bug something in this way and not the other way. I don't need to tell you to come up with scenarios there. But this is just a transcript of Joe's interview. None of that's relevant. So then finally, the mere fact that Congress subpoenaed the audio recordings and the president subsequently claimed executive privilege over them is little relevance here. That process of negotiation and accommodation is a political, not a legal process. FOIA, on the other hand, is a law passed by Congress and signed into law by the president. The court, therefore, can't act or ignore forever DOJ's and now the court's obligations under FOIA, especially since Judicial Watch submitted the FOIA request well before Congress subpoenaed the audio recordings. We asked this stuff before even Congress got to it. Not unusual. It's Judicial Watch. We're always ahead of the game. So they're all this executive privilege fight. That's a political fight with Congress. That's not a reason to withhold information under FOIA. It's a legal process. We have a right to know. You have a right to know about what the government's up to. Because they're getting a political fight with Congress about this. I don't care. I do care about it. We're voters. But it shouldn't impact our right to get the documents independently under federal law. In addition to asserting that the audio recordings fall into the law enforcement component of executive privilege, the Justice Department also argues the audio recordings are protected from disclosure under FOIA Exemption 7A, which allows the government to withhold records or information compiled for law enforcement purposes, but only to the extent the production of such law enforcement records or information could be reasonably expected to interfere with enforcement proceedings. Again, what are the proceedings? Case is over. 15 years ago, an organization called Crew submitted a FOIA request seeking copies of records relating to the interview of Dick Cheney by special counsel Patrick Fitzgerald in a closed investigation into the leak of the name of a covert CIA officer. The specific records at issue were an FBI 302 report summarizing the interview and two sets of contemporaneous notes taken by FBI agents during the interview. DOJ failed to disclose the records and Crew sued. During litigation, the Justice Department asserted various claims of exemption, including Exemption 7A. So there was a case almost exactly like this 15 years ago. To support its claim, the Justice Department argued that disclosure of the withheld records could reasonably be expected to interfere with enforcement proceedings because there are likely to be future law enforcement investigations requiring the participation of White House officials, and disclosure of Vice President Cheney's interview could have a chilling effect and deter such officials from voluntarily cooperating with those investigations. Of course, that's just didn't turn out to be true, and the court didn't buy it. The court rejected the claims of the Justice Department. And even though the law hasn't changed in 15 years, DOJ again tries to withhold similar records, relying on the same arguments rejected 15 years ago. As DOJ admits, this Exemption 7A, this law enforcement privilege for ongoing proceedings, essentially, documents and material related to ongoing proceedings, protects law enforcement records that could reasonably be expected to interfere with enforcement proceedings that are, quote, pending or reasonably anticipated. So the case is pending, that's easy to understand. Reasonably anticipated. They're sniffing around someone, they're not sure whether they're going to prosecute. They may, they probably will, and therefore they're not giving up any law enforcement related records. Makes sense, right? You know, if it doesn't make sense to you under FOIA as to why they withhold stuff, it's you're right to ask the question. Typically, that's been my experience as head of Judicial Watch with these FOIA cases and the fights we've been having for 30 years at Judicial Watch. It also admits that the D.C. Circuit, which is the appellate court in Washington, D.C., so here, it's the lower court judge. He has to follow the rules set by the D.C. Circuit, the appellate court above them. The government admits, the Biden people admit, that the circuit has held that pending or reasonably anticipated is, quote, temporal in nature. Reliance on Exemption 7 may become outdated when the proceeding at issue comes to a close. If a law enforcement investigation is closed, Exemption 7A most likely no longer applies. Like it did 15 years ago, DOJ also asserts the release of audio recordings could reasonably be expected to chill cooperation with reasonably anticipated future high-profile enforcement investigations. Possibly, maybe. However, this assertion ignores at least 40 years of binding precedent in which the D.C. Circuit has held Exemption 7A can't justify withholding records unless they relate to a concrete, prospective law enforcement proceeding. Makes sense, right?
Oh, they actually breaking the law.
DOJ does not identify any prospective law enforcement proceeding, let alone a concrete one, to justify its withholding. It rests on a fallacy, merely asserting the obvious. DOJ will conduct high-profile investigations in the future. Such contemplated proceedings are not concrete, prospective, or otherwise reasonably anticipated in any way whatsoever. Now, the judge who handled this case similar case 15 years ago, Judge Emmett Sullivan, I think he's still on the bench.
I stop right there to say, we allow criminals to just continue just robbing and fucking over us and doing all kinds of shit to us, and we do nothing. Just don't make no sense. It don't.